Good morning, everyone. Welcome to everyone here in Carson City, as well as anyone there in Las Vegas, and of course, those watching online through YouTube or Nellis. Committee Secretary, will you please take the roll?
Assembly members Cole.
Here.
Dahlia.
Here.
Gonzalez.
Here.
Gray.
Here.
Hanson. Hardy.
Here.
LaRue Hatch. Marzola.
Present.
Moore.
Here.
Nadeem.
Present.
Ornlicker.
Here.
Roth.
Here.
Urick.
Here.
Chair Miller.
Here, and please mark Hanson and LaRue Hatch present when they arrive. With that, just a few reminders. Please make sure you turn down the volume on your electronics, like I am doing right now. Also, we will have one bill presentation today. We will have public comment at the end. I ask that bill presenters keep their presentation to 15 minutes, and anyone testifying or making public comment, keep their comments to 2 minutes. Of course, just a reminder, please make sure you state your name for the record and spell it the first time you speak. And with that, I will go ahead and open up the hearing for Assembly Bill 309 and give our sponsor a few moments to get settled. And whenever you're ready, please proceed.
Good morning, Chair Miller, Vice Chair Marzola, and members of the Assembly Judiciary Committee. For the record, my name is Assemblywoman Melissa Hardy, and I represent Assembly District 22 in Henderson. I appreciate being here once again and given the opportunity to present Assembly Bill 309, which revises provisions relating to certain orders for protection against domestic violence. I have some presenters with me on Zoom, and I will introduce them in just a moment. Assembly Bill 309 seeks to clarify the process surrounding temporary protective orders, commonly referred to as TPOs, involving incarcerated adverse parties. Under current procedures, when an incarcerated individual is served with a TPO, there is ambiguity regarding the steps required for that individual to respond to an application for an extended protection order. This ambiguity has led to varied interpretations of what constitutes adequate notice, affecting both the due process rights of incarcerated adverse parties and the efficiency of court proceedings. It also creates uncertainty and stress for survivors who may face delays and multiple court appearances before obtaining necessary protections. To remedy this, AB 309 amends NRS 33.030 to clearly specify that a temporary protection order served upon an incarcerated adverse party must include explicit instructions. First, advising the incarcerated individual that the individual may contest the extended order by submitting an affidavit to the court within 14 calendar days after being served. Second, requiring the affidavit to detail specific reasons why the extended protection order should not be granted. And third, informing the individual that failure to submit the affidavit within the specified period will allow the court to hold the hearing in their absence and potentially grant the extended order without further input from that individual. AB 309 ensures clarity and consistency in providing adequate notice, improves procedural efficiency, and maintains necessary protections for survivors of domestic violence, while simultaneously preserving due process rights for incarcerated adverse parties. My co-presenters joining us on Zoom are Professor Courtney Cross, Director of the Survivor Representation and Advocacy Clinic at the William S. Boyd School of Law at UNLV, and Courtney Poe, an attorney at Holland and Hart, recent Boyd Law graduate, and former student attorney at the clinic. They will elaborate further on the important legal services provided by the clinic, the practical background driving this legislation, and a brief overview of AB 309. Thank you again for your consideration. I'll now turn it over to Professor Cross and Ms. Poe, also known as the Courtneys, and we are happy to answer any questions after we complete the presentation. Thank you.
Good morning, Chair Miller, Vice Chair Marzola, and members of the Assembly Judiciary Committee. For the record, my name is Courtney Cross, Courtney, CROS as in Sam, S as in Sam, and I'm so grateful for the opportunity to be here to present AB 309. As the Assemblywoman said, I serve as the director of the Survivor Representation and Advocacy Clinic at the William S. Boyd School of Law at UNLV. Our clinic provides critical legal services to survivors of intimate partner violence by, among other things, assisting them in securing temporary protection orders and extended protection orders. Our student attorneys, under my supervision, represent survivors throughout the protection order process, from that initial TPO all the way through the extension, which ensures that they have effective legal advocacy during a deeply vulnerable and challenging time in their lives. Thus far, the clinic has been in operation for 3 semesters. I came to UNLV from the University of Alabama specifically for the opportunity to design this intensive litigation-focused law clinic. I've devoted my own career to working with domestic violence survivors, and I've spent the last 15 years in various DV protection order courts in Washington, D.C., Colorado, Alabama, and now here in Nevada. Just this semester, my students and I have already provided both limited as well as extended representation to 34 DV survivors seeking protection orders, and we will continue to do that up until graduation in May. One significant challenge that our clinic has repeatedly encountered in these cases are issues where the adverse party is being held in jail when the temporary protection order is issued and served. Currently, the law doesn't clearly define how these incarcerated individuals may appropriately respond to an application for an extended protection order when they remain in custody at the time of an extension hearing. So these would be individuals who were arrested, typically on the scene of that domestic violence incident, and either are unable to pay bail. Bail has not been offered to them, but they are folks who have been arrested. They are served for us at the Clark County Detention Center, and they remain there through the pendency of that temporary protection order, and they won't be there for the extended order hearing. Now, in other states where I've practiced, these folks have had a right to be brought to the courthouse for these hearings. In Nevada, at least in Clark County, our adverse parties don't have the right to be brought to these hearings, which is why it's so important that we think through a way to make sure that they receive due process and that survivors are able to get closure on these cases. Because what we have found on multiple occasions is that the adverse party is served, we have prepared our client, which is, as you can imagine, a somewhat grueling and emotionally intensive process. We go to court and the hearing master understandably says, well, they're in jail, their failure to be here, is not due to their own choices. We're going to continue this again. We need to see if they get out. We have to see what happens to their case. And so we have had at least one case where we've had to go back 3 or 4 times, waiting to see what happens in this criminal case, whether the adverse party gets released. And it is a very traumatizing process for DV survivors to prep, to re-examine these incidents, which can be a triggering and traumatic experience, only to go to court and be told, you waited here for a while and we're just going to have to continue this case. And so what we have thought about is what is a way that we could thread this needle so that survivors would be able to access the extended protection that they were seeking in a way that would also allow adverse parties to receive the due process that they deserve, since their absence in court is because they're being held. And so the substance of this bill actually mirrors a procedure that has been used in a few of our clinic cases, in which the hearing master, in a continued temporary protection order, included language instructing the adverse party to respond by a certain date and letting the adverse party know that a lack of response by that date and a lack of appearance at the court hearing could result in an extended order being issued. Now, obviously, it wouldn't automatically result in that. The hearing master will still have what is essentially a hearing in default when that date comes, but it does provide clarity to the adverse party, letting them know what steps that they need to take, and it provides closure to the survivor who is able to see this protection order case finally end, hopefully with her desired result, but at least with some sort of closure and a conclusion to the case. So my former student, Courtney Poe, who I am so proud to be here with, is going to walk you in greater detail through the substance of the bill. I'm hoping to provide you the context to show you how the clinic became involved and interested in this issue. She's going to get into the nitty-gritty. And at the end, I am happy to answer any procedural questions that you may have about the DV protection order statute, procedure, timelines, etc. But thank you so much for your time. I appreciate being here.
Good morning and thank you. For the record, my name is Courtney Poe, Courtneypoe, and I will provide a brief walkthrough of Assembly Bill 309. Section 1 amends NRS 33.030, specifying that temporary protective orders issued against incarcerated adverse parties must include clear instructions outlining the process by which these individuals may respond. Specifically, the adverse party is informed that the incarcerated adverse party can contest the extended order by filing an affidavit with the court within 14 calendar days of being served the temporary order. The affidavit must detail specific reasons why the extended order should not be granted. Failure to submit this affidavit within the provided timeline may result in the hearing proceeding in their absence, allowing the court to grant the extended order without further input. Section 2 states these changes apply to all protective orders issued on or after October 1st, 2025. That concludes the section by section of the bill. Thank you again so much for your time and consideration. As Professor Cross said, we stand ready for any questions that you may have. Thank you.
Thank you so much. We do have a few questions to begin. First question will be from Assemblymember Gonzalez.
Good morning, and thank you so much for your presentation. So I have a few procedural question. How does a person go about doing an affidavit while they're incarcerated?
Thank you so much for the question, Assembly Member. By and through the chair, this is Courtney Cross.
Please go direct.
Thank you, CROSS. So the procedure that the hearing master had put in place was simply for them to fill out a response and mail it to the court. In terms of an affidavit and whether that has to be notarized, I think that there would be perhaps an opportunity for that to be done by a case manager out of county jail, but I do think that simply a written response that would be mailed to the court would likely be sufficient.
Thank you so much. In the handout that I received from Assemblymember Hardy, the first bullet states that the bill informs the incarcerated adverse party that they have 14 calendar days from service of the TPO to submit an affidavit contesting the extension. So I just was wondering clarity. Are you saying they don't need to have an affidavit, or that a written notice is sufficient, or can we get some clarity about that, please?
Sure. It does say affidavit. That's true, and this was an issue that I was thinking through this morning, because I know there is some variety over incarcerated folks access to something like a notary while they are detained in a local jail setting. I would be happy to chat with the bill's sponsor and to coordinate with others on the committee if folks were to prefer language regarding a written response. If it seems like sort of the threshold for an affidavit in terms of its notarization might be too high for an adverse party to be able to achieve.
Thank you. Our next question is from Assembly Member Roth.
Thank you, Chair, and thank you so much for that presentation. Actually, just piggybacking off that question, mine's very practical, just thinking about how this actually plays out in the jails. So whether or not there's a notary required or an affidavit required, what happens if the individual who's incarcerated wants to attend the hearing? And have you had any discussions with the jail regarding transport or facilitating via video or anything like that for them to be present for those hearings?
Thank you. That's a great question. This is Courtney Cross, CROSS, again responding. Yeah, I totally agree with the question that you're asking. When we have navigated this with our hearing masters, at least in Clark County, and again, I can't speak for other counties, but it has been suggested to me that there cannot be transport for folks, that if someone were to desire to be transported to family court, that might even be at their own expense. And when we've discussed the possibility for video appearances, which makes a great deal of sense, what was represented to me is that there is one morning video appearance possibility seemingly each month. And the understanding that I was given is that there are a great deal of logistical barriers to the ability for a prisoner to be present at these cases. So I truly understand your concern. This is actually the first jurisdiction that I've practiced in where there wasn't that mechanism for getting people either in person or remotely in front of the court, which I think everybody would agree is preferable. And so our work here with the bill sponsor was to think about if this truly is logistically unfeasible, what ways, if any, do we have to provide at least some opportunity for that person's voice to be heard? But I totally agree with sort of your interest in, are there ways for them to be present? My understanding in terms of what I have learned in a year and a half is that it's really, really challenging and that we were never able to actually have someone present either in person or via Zoom.
Assembly Member Gonzalez.
Thank you so much for the additional question, Chair. I was wondering, because you were talking specifically to Clark County, if you knew what other counties were doing and if other counties throughout the state have the same issue.
So this is Courtney Cross again. As I have chatted with the bill sponsor, I don't know what folks outside of Clark County are doing. I know that the bill sponsor would be happy to talk with folks who may have that sense. The clinic's work is limited to Clark County. And so my representations about what is happening on the ground are only about what's happening here in Clark.
This is Melissa Hardy for the record, and the professor's correct. This was just brought with incidents that we're seeing in Clark County. So as she said, we don't know the process in other counties, but we're happy to chat about that. But again, we were just trying to address what's happening in Clark.
Okay. Thank you. Not seeing any additional questions, I will go ahead and open it up for testimony. So starting here in Carson City, anyone that would like to come forward and testify in support of Assembly Bill 309?
Good morning, Chair, members of the committee. Serena Evans, SERENAEVANS, and I'm the Policy Director for the Nevada Coalition to End Domestic and Sexual Violence. This piece of legislation is a victim-centered bill. It kind of closes the loophole, reduces barriers for victim survivors when they have to go to a protection order hearing. It is oftentimes incredibly re-traumatizing, re-victimizes them. Not only that, but they often have to take time off of work and plan for childcare and things like that. So in order to keep rescheduling, keep postponing, it really does put their lives on hold. And so we are in support of this bill. Thank you.
Thank you so much. Is there anyone else here in Carson City that would like to testify in support? Not seeing anyone. Is there anyone in Las Vegas? Not seeing anyone that I believe is testifying. Avian, will you please open up the lines?
If you would like to testify in support of Assembly Bill 309, please press star 9 now to take your place in the queue.
Hi, Liz Ortenberger, LIZORTENBURGER. I'm the CEO for SafeNest, and we are in support of this bill. We see the justice system manipulated and used by abusers, and also unfair to abusive partners that are in custody constantly in the system here in Clark County. And just as a reminder, 80% of the domestic violence for the state rests in Clark County. So what other jurisdictions are doing is critical, but what's happening in Clark is the majority of the issue related to these TPOs. But we stand in strong support of AB 309. Thank you.
Thank you so much. Next caller.
Chair, there are no other callers to testify in support at this time.
Thank you. Then I will go ahead and open it up for opposition testimony. Is there anyone here in Carson City that would like to oppose?
Good morning, Angela Knott from the Washoe County Public Defender's Office, ANGELAKNOTT. I would like to apologize at the moment to Assemblywoman Hardy. We were not able to meet with her prior to today's presentation. When we reviewed this, we just have a lot of questions that are raised on the process. The notary was a big one that we discussed yesterday. Also in Washoe County, it's a little bit different. We do have like a mini court system in our jails. And as far as I know, after advising my client not to speak in any kind of court proceeding, even if they do proceed, usually it's like a phone call that they get to phone in to the court and be heard for these hearings. But we appreciate the idea of being something a little bit easier like an affidavit, but without maybe the notary requirement. Plus, how do they get this paperwork, right? This is something that the jail would have to provide for them with pencil, paper, and turn in for them. So I think we would just really like to work on this process to make sure everyone has an opportunity, a fair opportunity to be heard and make it a little bit more streamlined. Thank you.
Good morning, Chair Miller, members of the Assembly Judiciary, Paloma Guerrero, PALOMAGUERRERO, on behalf of the Clark County Public Defender's Office. I want to ditto my colleague from Washoe County. And I also want to delineate just two different situations for incarcerated parties, right? We have people who are serving prison sentences, so we know that their time is determinate, we know where they are, we know how long they'll be there. Then we have people that are in pretrial detention. These are the incarcerated parties in jail, where they're only there based on some sort of bond conditions. Maybe it's house arrest, maybe that's $500 bail, maybe that's $1,000 bail, and they're usually more fluid in how long they're in custody. It's not determinate. Whenever their family gets some money, they can bond out. So this doesn't account for the situation where that notice gets sent out to the incarcerated party, takes a few days, it has to process through the mailing system in the jail, and that person could have already been released. And then now they don't have notice, and now this hearing is being done without their presence. And then this says that it could be granted without their presence. So looking forward to working with Assemblywoman Hardy on these tweaks, and thank you.
Thank you so much. Is there anyone else here in Carson City? Not seeing anyone in Las Vegas. AVN, will you open the lines, please?
The public lines are open and working. There are no additional callers to testify in opposition of this.
Okay, thank you. Then I will go ahead and open it up for neutral testimony, beginning here in Carson City.
It's Maximilian Lowe for the record. It's Maxmillian Lowe. While I'm testifying neutral on AB 309, I would like to suggest an amendment to the proposed Section 6. Specifically, I recommend expanding the scope to include not only incarcerated individuals, but also clients who are under Aging and Disability Service Division ADSD services, particularly those served through regional centers and receiving supported living arrangements or SLA services who are accused of domestic violence or related acts. This change is important because current practices is if a client is served through a regional center, such as Desert Regional Center in Las Vegas, is arrested or accused of such acts, they're often removed from the home they share with the victim. Typically, they will be sent to a psychiatric hospital instead of jail, depending on the circumstances. While many service providers have internal policies in place, even when an Adult Protective Service or APS report or law enforcement report is filed, there are still gaps on how these situations are handled. For example, when the alleged perpetrator needs to return home to retrieve belongings, there's often little to no notice given to the victim. In my experience, I was notified by staff only moments before the individual was coming over, like when I was like 8:30 in the morning when I was just waking up. During one of those instances, despite being instructed not to speak to me, he verbally attacked me. Staff had to urgently call for additional support to ensure that I could safely leave the home without further confrontation. Adding language to Section 6 that would ensure that victims receiving services have adequate notice and protection in these situations would strengthen this bill and both protect individuals receiving ADSD services. Thank you so much.
Thank you. Anyone else here in Carson City? Not seeing anyone and not seeing anyone in Las Vegas. AVM, will you open the lines, please?
Public lines are open and working. There are no other callers to testify in neutral at this time.
Thank you so much. Then I will close testimony and welcome the bill sponsor back up for any final remarks.
Thank you, Chair. Melissa Hardy for the record. Is it okay for the professor to give some closing remarks? Okay,
Certainly.
thank you.
Thanks.
Thank you so much. I am heartened to hear that the bill has support. I understand that the two public defenders' offices may have some concerns that don't seem at all insurmountable. I know that we would love to coordinate with them and see if we might be able to address their concerns. The one thing that I would note is that with regard to people being held pretrial, which are going to be the vast majority of folks that are brought within the scope of this bill, they are served personally, usually within a day or two of that temporary protection order being issued. So there would not be a ton of delay on the front end with them getting served with these documents, because that is personal service. That said, I know that we are all anxious to coordinate and come up with a bill that will meet everyone's needs. I'm pleased to see that there isn't sort of a gulf of difference between, the public defender side, the victim-oriented side. So I'm grateful that they were here and that everyone was able to voice their thoughts on this, and we appreciate your time.
Thank you so much. And with that, I will go ahead and close the hearing on Assembly Bill 309. Next on our agenda is public comment. So is there anyone here that would like to make public comment here in Carson City? Not seeing anyone. I don't see anyone in Las Vegas. AVN, will you open the lines, please?
Chair, the public line is open and working. There are no callers to testify in public comment at this time.
Thank you so much. Then with that, we will go ahead and adjourn for the day, and I will see you all back at 8 a.m. tomorrow morning.